Bill C-12, officially called the Strengthening Canada's Immigration System and Borders Act, is moving through the Senate at an unusually fast pace and could become law soon. The bill is designed to respond to major pressure points in Canada's immigration and border systems, including a record asylum backlog, border security concerns, and the fentanyl crisis. For people with immigration plans, the most important question is how these changes could affect applications, permits, and asylum claims. This week, the Senate committee reviewing the bill has been hearing from senior federal officials and other witnesses. The timeline suggests the bill is approaching its final steps, with the committee moving toward a report and the Senate expected to consider it quickly afterward. Because of this pace, the bill could reach final approval and receive royal assent by late February or early March of this year. One of the biggest proposed changes is a new power that would let the federal cabinet take broad action on immigration documents in certain circumstances. This includes the authority to cancel, suspend, or modify large groups of documents, such as work permits, study permits, and visitor visas, if the government decides it is in the public interest. The idea is to allow faster response during situations like organized fraud, cyber incidents, public health emergencies, or national security concerns. This power is not meant to be used by the immigration minister alone. It would require an order approved by the full cabinet. Even if a mass action happens, it does not automatically remove someone's legal status inside Canada because existing processes and protections would still apply. The practical impact is that legitimate applicants should ensure their documents are authentic and that they are not unknowingly connected to a fraud scheme. The second major area is asylum eligibility. Bill C-12 would add new ineligibility rules that could change who gets access to a full refugee hearing at the Immigration and Refugee Board. One rule focuses on timing after first entry into Canada. If a person entered Canada after late June of the year 2020 and then waits more than 1 year to file an asylum claim, that claim could become ineligible for referral to the board. Another rule targets irregular border crossers coming from the United States between official ports of entry. If someone enters that way and then files an asylum claim more than 14 days later, they could also become ineligible for a full board hearing. In these situations, people would generally be routed toward a different process called a pre-removal risk assessment before deportation, rather than a full hearing. Some groups, such as unaccompanied minors, would be exempt from these ineligibility rules. The third area is expanded information sharing. The bill would broaden how immigration, refugees, and Citizenship Canada can share personal information across its own programs and with other federal, provincial, and territorial partners. The goal is to reduce duplication, improve program integrity, and detect fraud or inconsistencies more easily. In practice, that could mean less need to resubmit the same documents across different applications. At the same time, it could increase scrutiny, because inconsistencies between different submissions could be identified more quickly. The bill also includes privacy-related guardrails, such as requiring written information sharing agreements and limiting onward sharing to foreign entities unless conditions are met. The fourth set of changes focuses on speeding up asylum processing. The bill proposes a more unified process for claims made at a port of entry versus inside Canada, and it emphasizes sending only complete, schedule-ready files to the Immigration and Refugee Board. This is intended to reduce delays and prevent incomplete cases from clogging the system. It also includes measures like removing inactive cases, requiring the claimant to be physically present in Canada when a claim is decided, and making voluntary departures faster when a claim is withdrawn. The bill also strengthens support for vulnerable claimants by using designated representatives in situations where a person needs help navigating the process. The fifth area is border security and enforcement. While much of this is aimed at organized crime, auto theft, and fentanyl trafficking, the bill supports a broader tightening posture at the border. Measures include expanded authority for border officers to examine goods destined for export at places like transportation hubs and warehouses, new obligations for certain facility operators to support enforcement, and changes to the Coast Guard's security mandate. The broader message is increased enforcement capacity and more robust screening, which could affect travelers through more thorough checks. If you have an application in progress or plans to apply, the best next step is to double-check that all information across your immigration files is accurate and consistent. If you used an agent or consultant, verify that all documents are legitimate. If you are considering an asylum claim, timing matters under the proposed rules, so it is important to understand how the new deadlines could apply once the law takes effect. Finally, keep monitoring the bill's progress because the timeline is moving quickly and the final version could be enforced soon.